The Senate will please come to order. We'll begin this afternoon with a moment of silence. Thank you. Are there any announcements this afternoon? The senator from Windham is recognized.
Thank you, Madam President. I'm so used to making that announcement. My apologies. At this time, Madam President, I'd like to suspend rules pending entry on the notice calendar to have H433, the T bill, referred to approps in accordance with Rule 31.
Thank you, Senator. The senator from Windham has moved that the rules be suspended and H433, an act relating to the transportation program and miscellaneous changes to laws related to transportation, the T bill, be referred to the Committee on Appropriations. Are you ready for the question? Please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've referred H433 to the Committee on Transportation. Are there any further announcements this afternoon? We have two Senate bills for introduction. S-145, an act relating to permitting municipalities to regulate open carry of firearms, introduced by Senator Campion. Please listen to the first reading of the bill.
H-145, an act relating to permitting municipalities to regulate open carrying of firearms.
You've heard the first reading, and the bill is referred to the Committee on Judiciary. S-146, an act relating to space heating systems owned or controlled by the state, introduced by Senators Perchlik, Chittenden, Hardy, Hooker, Lyons, and Pearson. Please listen to the first reading of the bill.
S-146, an act relating to space heating systems owned or controlled by the state.
You've heard the first reading, and the bill is referred to the Committee on Institutions. We have three House bills for reference. H-265, an act relating to the Office of the Child, Youth, and Family Advocate, which passed the House on April 23rd, 2021. Please listen to the first reading of the bill.
H-265, an act relating to the Office of the Child, Youth, and Family Advocate.
You've heard the first reading of the bill, and pursuant to the rules, the committee is referred to the Committee on Rules. H-446, an act relating to miscellaneous natural resources and development subjects, passed the House on April 23rd, 2021. Please listen to the first reading of the bill.
H-446, an act relating to miscellaneous natural resources and development subjects.
You've heard the first reading, and the bill is also referred to the Rules Committee. And H-449, an act relating to the membership and duties of the Vermont Pension Investment Commission and the creation of the Pension Benefits Design and Funding Task Force. The bill also passed the House on April 23rd. Please listen to the first reading of the bill.
H-449, an act relating to the membership and duties of the Vermont Pension Investment Commission and the creation of the Pension Benefits Design and Funding Task Force.
You've heard the first reading, and the bill is additionally referred to the Rules Committee. This brings us to the orders of the day. We have in the calendar for action H89, read for the first time on February 25th, 2021. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill ought to pass. Please listen to the second reading of H89.
H89, an act relating to limiting liability for agritourism.
The senator from Windham, Senator White, is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. So for those of us who grew up on farms, the concept of agritourism might have seemed a little strange. The idea of going to a farm for our entertainment was weird. We knew where our milk, our meat, and our potatoes and lettuce came from. We worked long hours to make sure that animals were fed, gardens were weeded, and grain was harvested. This was part of our reality. The idea of going to a farm for entertainment was weird. We wanted to go to the circus, ride on a train or a plane, and use chemistry kits. We didn't want to visit a farm. But reality for many is not the same as ours was. More and more kids think that our milk comes from the grocery store. Our food also comes from the grocery store. They are not sure of the difference between a horse and a cow, or a chicken and a crow. So years ago, many folks started worrying about this and encouraging schools to take farm trips, families to consider visiting farms. This concern, combined with the fact that it is really hard to make a sustainable living by farming, led to a growth in the agritourism industry. We now have all kinds of events and tours taking place on farms. The experiences are good for non-farmers, and they are providing much needed income to farms. But there are liability concerns by the farmers. The concept of limited liability was brought by farmers to the legislature years ago. In fact, as far long back as I think 1990, but it went nowhere. All of our neighboring states, in fact, 30 states in the country, have enacted similar statutes, but we couldn't quite get there. After years of reworking and refining, we now have H89. H89 starts on page 1375 of today's calendar. Section 1 adds a new chapter to Title 12 for the limitation on liability for agritourism activities. It provides definitions for the chapter, and the key definitions are agritourism activity and inherent risk. Agritourism activity means an interactive or passive activity that is carried out for recreational, entertainment, or educational purposes on a farm, including farming, food production, historical, cultural, pick your own, and nature-based activities. Agritourism activity does not include lodging at a farm or shopping at a roadside farm stand, or operation exclusively devoted to the sale of merchandise or food at retail. Inherent risk means any danger or condition that is integral part of or arises from an agritourism activity, including the propensity of a wild animal or domestic animal to behave in ways that may result in injury or death to persons on or near the wild or domestic animal, a hazard such as a surface or a subsurface condition, a natural condition of land, vegetation, or waters, the ordinary dangers of structures or equipment used in farming, and the potential of a participant to act in a negligent way that may contribute to injury or death to the participant or others, such as failing to follow safety procedures or failing to act with reasonable caution while engaging in an agritourism activity. If a person climbs into the bullpen, there's no liability there. The person is at fault. Section 5872 establishes the limitation on liability for agritourism hosts. An agritourism host shall not have a legal duty to protect a participant from the inherent risks of an agritourism activity and shall not be liable for injury to or death of a participant or damage to the property of a participant resulting from the inherent risks of an agritourism activity, provided that the host posts the warning that's required in section 5873. 5872B provides the exceptions to the limitation on liability for the activity. Specifically, it does not apply to a host who commits a negligent or act or omission concerning the safety of a participant that causes injury or death to the participant, a host who has actual knowledge of a dangerous condition on the land, facilities, or equipment used in the activity, or the dangerous propensity of an animal used in the activity, which causes injury or death to the participant and does not make that danger known to the participant. An agritourism host who intentionally injures a participant or intentionally damages a participant's property, and a host who commits any other act, error, or omission that constitutes willful or wanton misconduct or criminal conduct that causes injury or death to the participant, or a host who fails to post the warning. Section 5872C provides that the limitation on liability for the activity shall not prevent or limit the liability of a host under product liability law. And D, any limitation on liability afforded to the host is in addition to any other limitations on liability otherwise provided by law, such as the limitation on liability for equine activities. 5873 sets out the warning notice an agritourism host must post and include in written contracts in order to qualify for the limitation of liability. It is very specific about the notice and what it has to say. I won't go into the required details of the sign unless someone has an interest in that. The effective date is July 1st, 2021. We heard from Michael Grady, our legislative counsel, Elizabeth Kennett, owner of Liberty Hill Farm, and Adam Necresson for the Vermont Association for Justice, commonly known as the trial lawyers. And in the past, they have been opposed to this bill, but are in favor of the way it is currently written. The committee vote was 5-0-0, and we ask for your support.
Thank you, Senator. The question is, shall the bill be read the third time? Are you ready for the question? The senator from Chittenden is recognized.
Thank you, Madam President. I don't have a question for the reporter of the bill, but I do have a comment. This bill has been in the works a long time, and I know that the chair of agriculture also knows about that. I worked on the bill two sessions ago with the chair from agriculture. We did have the bill that was not sent forward, but now with the improvements that we've made and worked with members of the other body, I am so pleased to see this bill go forward. I can't tell you the number of farms and farm people, sugarers, sugar houses, and folks who have contacted us about having this bill go forward for agritourism, because it certainly will improve the economic balance in the rural parts of our state. And I just will say one last thing. Having grown up in a farming community, we did look at tourism as hopping on the horse at the end of the week and taking a picnic down by the stream. So thank you, Madam President.
Thank you, Senator. The senator from Essex Orleans, the chair of the Committee on Agriculture, is recognized.
Yeah, I just want to comment and thank the Judiciary Committee for all their hard work on this. And as the other speakers have said, we've been an awful long time getting this enacted, but really think that it's going to be positive for our farmers to have more agritourism, and it's going to protect the visitors as well. So it's a good bill. It was put together well, and I think everyone is protected and happy with it. So again, thanks to the Senate Judiciary Committee.
Are you ready for the question? The question is, shall the bill be read a third time? Kindly unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay.
I'll do.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of H89. We have on the calendar for action H46, read for the first time on March 19th, 2021. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends the bill be amended as set forth on pages 1,375 to 1,376 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H46.
H46, an act relating to miscellaneous provisions of mental health law.
The senior senator from Chittenden, Senator Lyons, is recognized for the report of the Committee on Health and Welfare.
Thank you, Madam President. May I speak to both the underlying bill as well as the amendment?
You may.
Thank you. And the amendment is on page 1375 of today's calendar. H46 represents continued work by your Senate Health and Welfare Committee to improve the system of care for those with mental health needs in our state. It builds on the work that we've done in areas of transparency and support for patients who voluntarily are seeking inpatient mental health treatment, or for those who are being treated as involuntary patients. The bill continues our work to provide systemic improvements for our mental health system, ensuring that the system is integrated as a system of care. The bill improves notice to patients who are in care and adds a data collection that can improve mental health patient care over time. Section 1 of the bill provides information to a person who voluntarily seeks mental health treatment and adds a condition for that. So when folks go in to seek mental health treatment in a hospital as in a voluntary way, there is a consent form that they are given to sign so that they understand what's going on. We've, in the bill, and the underlying bill as it came to us, there is a section that says that the person understands that inpatient treatment may be on a locked unit and a requested discharge may be deferred if the treating physician determines that the person is a person in need of treatment pursuant to 7101. And what that means, if the physician determines that the patient may be in danger of causing harm to self or others, the treating physician may defer their release. And that's in underlying statute. The change that we made in the bill is really fairly innocuous. We changed the term he or she to person to allow for consistency in the identification of the individual. Section 2 of the bill is, again, it's an assistance to a patient so that the hospital would provide information to the patient when they are applying to move from involuntary to voluntary status. And so the assistance is in filling out the forms that the patient would ask for discharge from involuntary to voluntary status. Section 3 of the bill establishes certain data that will be collected by the hospital for any emergency involuntary procedures for patients who are admitted to the psychiatric unit. This is in the context of legislation or of the law itself, of the statute that prioritizes treatment. So treatment is prioritized first as outpatient, secondly as partially in hospital, and thirdly as in-hospital inpatient treatment. Section 4 of the bill builds on Act 200 of 2018. This is the act that really has helped us provide systemic improvement to our mental health services in the state and to ensure integrated system of care. The change that is here is to eliminate the data collection that we saw on the previous page, and because now it is already collected. And then the other thing that happens in this part of the bill in section 7 is an extension of the reporting period to the Department of Health, to the Commissioner of Mental Health. And the extension of reporting on mental health issues is critically important as a result of COVID. The reporting process has been the treatment of patients in our mental health environment has been very much interrupted and influenced by COVID. So this allows for the collection of data continuing until 2023. So, Madam President, that is the bill. We heard from the Commissioner of Mental Health. We heard from the Deputy Commissioner of Mental Health. We heard from the Supervising Attorney of the Disability Rights of Vermont, and of course from our Ledge Council. The vote in committee was 5-0-0, and we ask that the Senate concur with our proposal. Thank you, Madam President.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? Kindly unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've proposed to the House to amend the bill as recommended by the Committee on Health and Welfare. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've ordered third reading of H46. We have on the calendar for action H104, read for the first time on March 19th, 2021. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the bill be amended as set forth on page 1376 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H104.
H104, an act relating to considerations in facilitating the interstate practice of healthcare professionals using telehealth.
The senator from Rutland, Senator Terenzini, is recognized for the report of the Committee on Health and Welfare.
Thank you, Madam President. May I speak to the bill and the amendment?
You may.
It's my privilege to represent the Senate Health and Welfare Committee today as I report on H104, an act relating to considerations in facilitating the interstate practice of healthcare professionals using telehealth. You will recall that earlier in the session, your Health and Welfare Committee spent countless days discussing telehealth, and this body voted in the affirmative to support this practice. In the wake of this global pandemic, ensuring that patients could still meet with their providers has been critically important. This bill, H104, marries nicely with our earlier work and allows for the study process to begin to address issues related to the interstate practice of healthcare professionals using telehealth beyond the COVID-19 global health crisis. Section 1 of the Bill A calls for the creation of a working group to compile and evaluate methods for facilitating the practice of healthcare professionals throughout the United States using telehealth methods and models. Section 1B, the working group will be comprised from the following positions. The Director of the Office of Professional Regulation, 2 representatives of the healthcare professions associated with the Office of Professional Regulation, selected by their respected licensing board or by the director. 3, the Executive Director of the Board of Medical Practice. 4, representatives of the healthcare professions licensed by the Board of Medical Practice, selected by the Commissioner of Health. 5, representatives of healthcare profession organizations. 6, representing of healthcare insurers, and 7, other interested stakeholders. And the amendment that I was referring to as well adds to the working group the Commissioner of Mental Health or a designee. Section 1C, the power and duties. The working group shall compile and evaluate methods to facilitate the interstate practice of healthcare professionals using telehealth models, including through the creation of telehealth licenses, waiver of licensures, national licensure compacts, and regional reciprocity agreements, and evaluating potential options for implementation in Vermont. The working group shall consider the following. 1, impacts and ethical considerations related to patient care and continuity of care. 2, whether to limit to healthcare professionals with pre-existing patient relationships. 3, impacts on state regulatory oversight and enforcement, including the fiscal impacts. 4, effects on prescribing medications. Number 5, differences between the various states and U.S. territories and scopes of practice, qualifications, regulations, and enforcement. 6, different policy options for facilitating interstate practice, including the potential for reciprocity with healthcare professionals licensed in Vermont. 7, whether to explore the international practice of healthcare professionals using telehealth. And 8, other issues relevant to facilitating the interstate practice of healthcare professionals. The report on or before December 15th of 2021, the Director of the Office of Professional Regulation shall provide the working group's findings and recommendations to the House Committees on Healthcare and on Government Operations and the Senate Committees on Health and Welfare and Government Operations. We heard from the following in committee as witnesses: Jessa Barnard, Executive Director, Vermont Medical Society; Jennifer Carby, Deputy Chief Counsel, Office of Ledge Counsel; Lauren Hibbard, Director, Office of Professional Regulation from the Secretary of State's Office; Mitul Patel, VLS Student Clinician, Office of Legislative Counsel; Representative Arthur Peterson, reporter from the House Committee on Healthcare; and Commissioner Sarah Squirrel from the Department of Mental Health. This is a straightforward yet critically important bill, which takes a thorough look at how providers continue to offer exceptional care for Vermont patients. Your Health and Welfare Committee passed this bill out at 5-0-0, and we ask for your support. Thank you, Madam President.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? Kindly unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Health and Welfare. The question now is, shall the bill be read for the third time? Are you ready for the question? Kindly unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of H 104. We have on the calendar for action H 108, read for the first time on March 12th, 2021. It was referred to the Committee on Natural Resources and Energy, which reports it has considered the bill and recommends that the bill be amended as set forth on pages 1376 to 1379 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H 108.
H 108, an act relating to Vermont standards for issuing a Clean Water Act Section 401 certification.
The senator from Addison, the chair of the committee, Senator Bray, is recognized for the report.
Thank you, Madam President. Again, the Senate Natural Resources and Energy Committee reviewed House Bill 108, an act relating to Vermont standards for issuing a clean water Section 401 certification. And we're recommending that the Senate propose to the House that the bill be amended by striking out all after the enacting clause and inserting the language that begins on page 1376 of today's calendar. Before reviewing the language of the bill itself, I'd just like to provide some background information. Overall, the bill addresses a gap in current law on the protection of wetlands. And as I think many members, maybe all of us know, wetlands are some of the richest and most valuable resource lands we have in the state of Vermont in terms of their function and the diversity and richness of their biology. So they are worth protecting, and this bill addresses filling in a gap in current law to enhance that protection. Stepping a little further back, the bill refers to a Clean Water Act Section 401 certification. So Under the Clean Water Act, dating all the way back to 1972, a federal agency may not issue a permit or license for an activity that may result in a discharge to waters of the U.S. unless the state where the activity is proposed issues a certification that the proposed activity will comply with the state's water requirements. Here in Vermont, our water quality requirements are codified in the Vermont Water Quality Standards. The Vermont Water Quality Standards also include a process, as well as the standards themselves, for issuing a 401 certification. Although the Agency of Natural Resources' historic practice in reviewing and issuing 401 certifications has been to review the potential effects of any activity on wetlands and then to impose, if necessary, conditions to protect them. In the current Vermont Water Quality Standards, we don't refer specifically to wetlands. Recently, actions in other states highlight the value of 401 certification and as they relate to wetlands. And that is that projects have been proposed that traveled through wetlands, and the 401 certification process was allowed to address issues of water quality impacts when the state's water quality standards explicitly named wetlands in the standards. So to get to the punchline here, what we're doing here is we're saying that the A&R practice of applying 401 certification to wetlands will be formalized in two ways. First, really in Section 1, we amend the statute to specifically reference the standards A&R will require compliance for a 401 certification. And in the second section, we go on to correct the omission of wetlands from the Vermont Water Quality Standards by requiring A&R to include wetlands under the Vermont Quality Standards, and they do that through a rulemaking. Section 3 lays out details of how the rulemaking happens, and Section 4 is just the effective dates. So turning to the bill itself, again, which begins on 1376, Section 1 formalizes the A&R certification process in statute. Simply put, on the top of page 1377, you'll see a list of programs that require 401 certification, and we now list sub A, 10 VSA Chapter 37, which includes wetlands protections and water resource management. Secondly, in sub 2, we go on to say what are the tests that an applicant must meet in order to gain such certification. And there's a list here that there must be A, for instance, no practicable alternative; B, that the proposed activity won't result in a violation of other water quality standards; C, the proposed activity will not result in violation of the state's anti-degradation law. And so those three tests are applied. In sub 3, we go on to add a definition of what we mean by a practicable alternative. In sub B, we add an exclusion, that is that you don't fail the test if the area, the type of project you're bringing forward does not require the application of a 401 test. And that is not because it's entirely unregulated, it's because there are other bodies of law doing environmental reviews. And we'll come to 2 instances of those later in the bill. In sub 4, on the top of 1378, we provide that the secretary issues certification, but we also add a prudent clause that unless the secretary determines that an individual review of the applicant's activity is necessary to assure compliance with the Vermont Water Quality Standards. So there is the ability for the secretary to see a nexus to water quality standards that may not be apparent at first review, and dig in deeper. So a prudent review. Then we get to section 2. How do we do this? We go through a rulemaking and we lay out the areas in which rules will be written in sections 1, 2, and 3. And I'll draw your attention to the last sentence of sub 3, which was an addition that the committee made. And that sentence reads, railroad projects or state or municipal road or highway projects shall be exempt from the requirements of the preceding section 401 review language that we just reviewed. And that is because there's another review process that goes with railroads and highways. Not that there's no review, but an alternate review. Section 3 lays out the timing for the rulemaking. For instance, that it shall commence on or before January 15th and conclude on or before March 1st of 2022. And then section 4 provides the effective dates. We heard in the development of this bill from James Dumont, lawyer, John Groveman of the Vermont Natural Resources and Energy Committee, Commissioner Peter Walk of the Department of Environmental Conservation, Councilor Matt Chapman, General Counsel, Agency of Natural Resources, Michelle Boomhauer, Agency of Transportation, Warren Coleman, representing Utilities, and Michael O'Grady of Legislative Counsel. Committee vote was 5-0-0, and we would ask for your support.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Natural Resources and Energy? Are you ready for the question? The senator from Essex Orleans is recognized.
Yes, may I inquire of the Senator Addison?
You may.
Yes. Could Senator Bray tell me? I heard your list of people that testified, and I didn't hear anyone like the Secretary of Agriculture or anyone representing ag. And so I'm wondering, there's a lot of wetlands or a lot of land on farmers' land that they mow and look after and plant crops on, that people from A&R and other agencies consider to be wetlands. And I'm wondering, with the way things are going, a lot of farms are putting in drag lines to do their manure spreading, so it cuts down on fuel use, and running on roads with trucks with manure spreaders, and sometimes they even put a satellite pit out in a field, and I know one farmer's had trouble already with A&R classifying where they were going to put that pit as a wetlands area, and it's been farmed for forever. And so I'm wondering, what kind of testimony did you get from the ag community in regards to your bill?
Thank you for the question. So we didn't have ag community direct testimony. We did raise the issue with Councilor O'Grady. What were the implications for agriculture? And in part, I think that's because I spent my first 5 years in the State House on ag committees. So I'm very aware of the issue. Because a 401 review is a permit for an activity that discharges to the waters of the U.S., and farms don't have discharges under normal circumstances, there's not a connection for the 401 review on normal farming activities. But I would be happy to, I would just add that once probably the most useful thing for you and I to do between now and third reading might be to have a conversation together with Mr. O'Grady, because there is a lot of subtlety and connections in the law. So at any rate, I think the short answer is that ag is not affected by this, but I'd be happy to work with you, Mr. O'Grady, to make sure you're satisfied with all the implications.
Yeah, thank you, Senator, and appreciate that.
Yep.
Thank you, Madam Speaker.
Thank you. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Natural Resources and Energy? Are you ready for the question? Kindly unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and you propose to the House to amend the bill as recommended by the Committee on Natural Resources and Energy. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please signify by saying aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and you've ordered a third reading of H 108. We've had a request to pass over H 438. Without objection, we will do so. We will move to S 45. We have on the calendar today S 45, an act relating to earned discharge from probation. The House has proposed to the Senate to amend the bill as set forth on pages 1382 to 1385 of today's calendar. The underlying question is, should the Senate concur with the House proposal of amendment? The senator from Bennington, the chair of the Judiciary Committee, is recognized. Senator Sears. Senator, kindly unmute.
Oh, I know that's the bane of being on Zoom. Madam President, the Judiciary Committee reviewed the changes proposed by the House on S-45, the act relating to probation discharge, and remind the Senate that this is part of the Justice Reinvestment 2 efforts. We found there were only really, even though it's a strike all, there are only really two changes from the Senate version of S-45. They are, the House created a new section 2 that adds language that that requires the prosecutor's office to inform the victim of the midpoint review process as established in the bill, including that the defendant may be eligible for early discharge from probation as a result. They then made a slight change in our section 3, their section 4. You'll see it in section 4 of their strike all amendment. We had put in that the offender has completed any rehabilitative or risk reduction services, the duration of which are set and knowable at the onset of probation that are required as a condition of probation. They did not like the word any and changed it to has completed those rehabilitative or risk reduction services required as a condition of probation that have duration that is set and knowable at the onset of probation. So those are the only two changes. Your Judiciary Committee decided to urge the Senate to concur with the House proposal of amendment on S-45 by a 5-0-0 vote.
Thank you, Senator. The question then is, shall the Senate concur with the House proposal of amendment on S-45? Are you ready for the question? Kindly unmute. All those in favor, please signify by saying aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and you concur with the House proposal of amendment on S-45. There's been a request to pass over S-114, and without objection, we will do so. That then brings us to the completion of the orders of the day. The senator from Wyndham is recognized.
Thank you, Madam President. At this time, I ask that S100 be placed on the action calendar.
The senator from Wyndham has called up S100, and the bill will be on the action calendar for tomorrow. The senator from Wyndham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until Thursday, April 29th at 1 p.m.
The senator from Wyndham has moved that subject to any announcements, the Senate do adjourn until Thursday, April 29th at 1 p.m. Are there any announcements this afternoon? The senator from Caledonia is recognized.
Thank you, Madam President. Senate Appropriations will meet 15 minutes after the fall of the gavel. Thank you.
Thank you. And the junior senator from Caledonia, with respect, is also recognized.
Thank you, Madam President. First, with respect to the entire body, the Senate Secretary is sending out a copy of the spreadsheet that belongs to the Capitol bill. That spreadsheet will have some colored markers on it. You will see from the spreadsheet's colored markers, there's red markers. That's what the House did to make changes to the governor's recommendation. There are green markers, which is what represents your Senate Institutions Committee's changes to that. They are very short, but they are pertinent for tomorrow's conversation. With respect to the Institutions Committee itself, I would ask all members to be present on time at 2:15. Thank you, Madam President.
Thank you. The senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet 15 minutes after the fall of the gavel.
Thank you. The senator from Wyndham is recognized.
Thank you, Madam President. Senate Government Operations will meet at 2 o'clock.
Thank you. Are there any additional announcements? The senator from Caledonia is recognized.
Thank you, Madam President, for allowing me to speak twice. I would just like to indicate that summary documents as background for the FY22 budget will be emailed out to senators this afternoon, late afternoon, by then, so that we can have the material ready for review and people will have an opportunity to have read the information before we do an all-member caucus tomorrow. I believe it's at 11:30. So I just wanted to let everyone know that material is being sent out, summary material to help take a 200-plus page document into something that is somewhat into highlights and areas of change. So thank you.
Thank you. The senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet at 2:15.
Thank you. Are there any additional announcements? Seeing none, hearing none, the senator from Wyndham has moved the Senate adjourn until Thursday at 1 p.m. Are you ready for the question? All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and the Senate stands adjourned until Thursday.